Thank you, Rebecca. And let me actually first thank you and Susanna and Johanna and Christina and all of your colleagues from Bitkom. This is just a world-class event, and it's really a privilege to be a part of it, so thank you. And it's also a privilege to be a part of the discussion that we are about to have with our panel. I think everybody knows Peter, but let me ask the other panelists to come on up. We'll just go in the order in which I see them, maybe with Axel Kessler. Come on up. He's the head of data privacy legal at Siemens, and in that capacity, he's responsible for the data privacy program for all Siemens Group companies as well as its 360,000 employees. So that's how I got to know that little factoid. And then we have Caitlyn Fennessy, who is the lead on the Privacy Shield team in the U.S. International Trade Administration, which is a part of the U.S. Department of Commerce. Another fun fact is that about a decade ago, Caitlyn and I were in the same office, the Office of the U.S. Trade Representative, negotiating trade agreements. So it's funny how life takes you different places. And then we have Helen Dixon, who is a stranger probably to no one, the Data Protection Commissioner for Ireland, and echo Emily Sharp's comments earlier about the high regard I think that we all have for Helen and her colleagues in Ireland. And then finally, Claire Bradshaw, who's the Deputy Director for the International Data Unit at the UK Department for Culture, Media, and Sport. We've decided to continue to try to be provocative. I'm not sure I can top the ABBA comment, but we will try to do that. And we're also going to try to be conversational. So I have a bunch of questions. It's no problem with me if I'm ripping them up after 5 minutes, and I'll invite the panelists to pose questions to each other, and hopefully you'll get to see us sweat under these lights here a little bit. But Peter, why don't I just start with you and see if, I mean, what you just said was just profoundly important in my view about the nature of data or the non-nature of data. As we get into this topic of GDPR and in particular international data transfers, which is the segment of this that I'd like to emphasize, any additional sort of threshold thoughts that you think are important to put out for folks?
Well, just some of the trends to keep in mind. Is this on? Yeah. I think this needs to be turned on. Okay. It's a few thoughts. Remember, the total amount of data in the world is doubling. It's growing logarithmically. It's doubling people estimate about every year and a half. Which means that if we think there's a lot of data now, just wait. Right? When things double, that double, that's a lot of stuff that we need to be thinking about. The internet was designed for global transfers. It was designed to essentially be a network that would move data around the planet to follow the most efficient path. And that is proven to have been a brilliant architecture. I mean, it wasn't obvious when people first came up with this, 30-odd years ago, but it turned out to be absolutely brilliant. So I think it's the way forward. As companies, we have to comply, we have to build compliance programs to comply with legal obligations around things like international data flows, if those are the laws that the legislators pass. And it's curious to me that even though you heard what I think about that as a model and as a regime, it is still very much the fashion. And if you look at new privacy regimes being proposed, for example, in India, or being passed in many countries around the world, they are still reprising this idea of international data flows as something that needs to be regulated, as the thing that you can grab onto. Now, in some of those countries, like India, they're also talking about data localization. Data's got to stay in my country. And it's a secret to nobody that, it's partly a privacy debate, but it's also really a protectionist debate too. I mean, that's pretty obvious, I think, to everybody. So all I'm saying is, even though it seems very retro to me, boy, is this alive and well on the legislative framework, even in new laws that are being discussed around the world, and of course, taken up by the GDPR all over again.
Yeah, great. So let's start in Europe, and Helen, we'll start with you, because you are, of course, at the very center of many of the pressing questions of data protection, and in particular international data transfers. We've got the Irish litigation, including the issues referred to the ECJ with respect to standard contractual clauses. Where, to the extent you can discuss it, where do those cases stand, and any particular observations about the issues in those cases as they relate to this larger topic?
Yeah, sure. Thanks, Josh. Just to start off with a couple of points on what Peter outlined earlier. First of all, everybody does love a birthday, but only when there's cake. So not sure there was much point in bringing it up. But of course I agree with you in terms of what you said about the internet is made for data transfers, and global connectivity is an expectation of every consumer and user. But equally, of course, we have the case, which we all well understand, that where laws exist, such as the laws and the Charter of Fundamental Rights in the EU, that protect users' rights, it cannot be the case that simply by moving the data around to another jurisdiction, users should have an expectation that they'll lose those rights. So of course, this whole topic of data transfers, even if we sometimes argue that the way in which the internet works and the ways in which the laws are written and the description of what constitutes a transfer sometimes seem to have something of a disconnect, I think we can still all understand that the rights in some way have to travel. So yeah, I think if I could take a few minutes and give an update on the litigation that my office initiated in the Irish High Court, because I think it is particularly important, and I suspect it might touch a little bit on some of the comments Claire will make later on. So without going back into the full history, just to give you the 2018 update on that litigation that we initiated in May 2016. Of course, this year, the Irish High Court judge finally in April compiled, having heard from all the parties to the case, including Max Schrems, Facebook, compiled the list of questions to be referred to the CJEU. So the reference has been made. In fact, the CJEU has already invited written submissions from the parties over the summer. So I anticipate that case is likely to be heard in the first half of 2019. And I think the reason, of course, we have a lot of empathy for the fact that there's huge stress around the topic of transfers for companies. A lot of the privacy professionals we engage with are trying to argue with their boards to get big budgets to implement compliant solutions to transfers, and yet they're doing it against a backdrop of great legal uncertainty in light of the litigation. But I think this litigation is different in that there was a very extensive, almost 6-week hearing in the Irish High Court. There was a huge adducing of facts from the preeminent experts on national security law and law in the US during the hearing. So the questions that are now being transmitted to the CJEU and the statement of facts going with it are probably the first time there's been a very comprehensive outline of the issues. So it's our hope that the positive that's going to come out of this is that the CJEU will be answering questions that we really do all need to bottom out on. Otherwise, we're going to keep moving from solution to solution and legal doubt to legal doubt on it. So just to very briefly mention some of the questions that were referred, but of course it goes without saying the CJEU may answer those questions or it may repackage the questions and answer a different set of questions. But important things I think that we're going to sort out are whether the Charter and the Gdpr do apply to processing that occurs in a national security context. We're also going to sort out what is the comparator for a third country. It was argued in the case in the High Court that, well, surely it's not fair that the US, for example, is being compared to the Charter and the directive as it was then pre-GDPR, when we can see that there are practices by intelligence agencies in some EU countries that don't seem to meet the standard we're being held to. So what the comparator is an important question to sort out. The role of data protection authorities, it was argued again in the High Court that there's no need for this reference case under Article 28.3 of the directive as it was, and Article 4 of the SCC's decision. DPAs can suspend transfers if they think that rights aren't being protected. So it was argued, why didn't the Irish DPC just suspend Facebook's transfers? We, of course, argue that would not have resolved the issue that we argue is an issue that EU persons don't have an effective judicial remedy in the US. So I don't want to take up all the time, but I think there's important questions based on a huge gathering of evidence, including and importantly from US experts during the hearing, that's going to allow now for a proper treatment of this important subject at CJEU level.
Great. Thank you, Helen. Well, obviously, I'll be following that really closely. Caitlyn, let's go to you and come across the Atlantic. You obviously spend most of your time thinking about the Privacy Shield, but I want to put you on the spot about something that's been in the news very recently and that a lot of us, both in the United States and elsewhere, have been thinking about, which is what's happening in the United States, and in particular, thinking within the executive branch about a potential framework for privacy. Can you tell us a little bit about what the department is thinking about and what the government is thinking about on that?
Sure. Happy to make some brief comments in that regard. What I can say is that the White House, the National Economic Council, tasked the Department of Commerce with working to develop a forward-thinking strategy to address privacy challenges in a way that also supports and enables innovation. As Peter discussed, data is expanding exponentially. Obviously, we're all well aware that privacy issues are very top of mind these days for companies, for individuals, for regulators. So everyone agreed this was a very opportune moment to take another look at the model and think about the path forward. So as you may have seen just, I believe, yesterday, the Department of Commerce published a request for comment outlining top-level privacy outcomes that we are looking to achieve and a set of goals as to how those could be best achieved, and basically put the questions out there as to how stakeholders think those outcomes and goals could be best achieved. And I'm always encouraged to point out that our requests for comments are completely open. We very much welcome input from stakeholders around the world, whether regulators, companies around the world, individuals. So I encourage you to take a look at that. And submit comments. We will continue to have stakeholder consultations as our agency, which is comprised of a number of different bureaus, will work on different work streams of this project. So whether it's the National Institute for Standards and Technology will have one component of this. My department, the International Trade Administration, will continue to look at the international and interoperability pieces, and the National Telecommunications Information Administration focuses on the domestic components there. So I welcome that.
And there are no restrictions on who may submit comments, right?
No, absolutely
Okay.
not, yes.
So take her up on that offer. This is really important. In fact, I'll just divert for a minute to say that this is also a process that industry is deeply involved in, sort of in parallel with the U.S. administration, whether it's U.S.-based trade associations or global organizations like mine. My colleagues Guido and Sana are deeply involved in driving a lot of the thinking with our member companies about how to be a part of the solution, how to support the U.S. government in coming up with a policy recipe, whatever form it may take, that is truly interoperable, reflects truly high standards of privacy protection, and can help solve some of the issues of fragmentation that we have. So thank you. Claire, let's go to you. Whether it's the litigation in Ireland, whether it's things you see across the Atlantic, whether it's things you see in your own country, especially as Brexit approaches, what's your assessment of these developments from whatever perspective you think is most relevant?
Well, thank you. And certainly as the head of the unit that is in charge of ensuring we have a smooth, orderly exit from the European Union and ongoing data flows, this is the issue that really keeps me up at night. So I'm very happy to take ideas from the audience on how we sort of manage this going forward. You know, I think we all recognise the importance of data flows to our modern economy. If we take sort of Germany and the UK alone, 7 billion euros of exports, are data dependent. So it's absolutely vital for both of our economies that we continue to have data flows, and they underpin nearly every facet of the modern day economy. They're also critical for national security and law enforcement sharing, but also from a kind of UK perspective, we've been given a very, very clear signal on the back of the Cambridge Analytica and Facebook incidents that our citizens really care about where their data goes. They care about how it's being used, and they really want to make sure that our regulators are enforcing if there are any breaches involved in their personal data. So from a UK perspective, we've got a real challenge on our hands at the moment. And, you know, we've heard about some of the potential disruptions to international data flows through legal cases, but also the biggest challenge that we face at the moment is the political turbulence involved. And from a Brexit perspective, one of the things that we've had to do from a UK government is really make sure that we're preparing for every scenario. And if we exit the European Union in March next year without a deal, we are facing a real cliff edge on data. And this is not an academic issue. This is going to affect every single one of us in our lives and how we, you know, communicate, how we share information, how our companies operate. And when we have had to face this issue of looking about how do we make sure that we have continuity of those data flows, we're really kind of crossing untrammeled boundaries. You know, we've got a few examples from the safe harbour experience of how to approach this, but there have been a number of challenges, and I wanted to share those with you today and also kind of get the panel's thoughts. I mean, firstly, when we talk about the impact of disruption to international data flows, what do we really mean by that? So when I've had my team go out and we speak to businesses, we speak to fellow kind of counterparts and other governments, we don't have a clear collective understanding of how important data flows are and what the disruption to those data flows will be if we see adequacy agreements fall, if we see standard contractual clauses fall away. And that makes it very difficult for policymakers like myself to influence politicians. So when I'm sat briefing ministers and I'm trying to make them understand the importance of this thing called data, you know, it's a real struggle for me because there is not a kind of consensus in the community about how much we value these and what the impact would be on our economies and on our sort of services, whether that be law enforcement or national security, if they fall away. So that's the first big challenge. The second one is sort of how do you do contingency planning? So you'll have seen that the kind of UK government has recently put out technical notice, and we've been working very closely with our Information Commissioner on this. But how do we really make sure that we're advising and giving businesses all the information that they need in advance, and how far lag time do they need to prepare in terms of putting measures in place? We have lots of engagement with UK businesses and lots of sort of frank exchanges. Some of them are often more difficult for me to handle than others, but it's a real kind of pressing issue. How do we as policymakers make sure that we've actually got decent contingency measures in place? And the last thing that sort of we've really kind of come up across is to try and sort of take the politics out of this, which obviously in a Brexit context is far easier said than done. But, you know, in all seriousness, if we recognise that data flows are absolutely pivotal to how we do business, to how we operate as citizens, how do we come up with kind of pragmatic solutions to make sure that those international data flows are not disrupted, regardless of sort of what our politicians are thinking? So as policymakers, we've really, really pushed our government to try and take a pragmatic approach to this. So some of you sort of more detailed experts who have scrutinised our technical notice might have observed that actually we've taken the decision to recognise the EU as adequate. So when we leave next year, if it is in a no-deal scenario, we have recognised that member states on the 31st of March will have no different regulatory frameworks than what they will on the 1st of April. So we have said in our domestic legislation, in the event of no deal, that data flows will continue to be able to flow from UK businesses to Europe. And we are strongly advocating that we start the adequacy process now with the Commission, because we want to just make sure there is no disruption to these flows. But these are really tricky issues, and I don't think sort of my government and other counterpart governments have come up with the solutions to this yet. But hopefully, in the Brexit context, the things I've spoken about will not be tested. But I don't think they're going to go away. And I think we all need to be kind of honest and frank and come up with sort of really pragmatic solutions to how we make sure that these fundamental aspects to our economy and the way that we live is maintained regardless of the political scenarios.
Thanks so much. A kind of asked if I could make some comments because I think you raised some really important issues. And I'm not going to focus specifically on the Brexit piece. Obviously, you're the experts there. But what I wanted to touch on is that I feel like you pulled together the strings so far discussed on this panel. We heard from Peter about kind of the technical reality. We heard from Helen about the legal reality. And you posed the question as to how we in a pragmatic way, approach those two realities and what the impact is. And I just think that is what we have always considered our role at the Department of Commerce, trying to inform the policymaking process, what I touched on earlier, by injecting what the technical reality is so that the policymaking reflects that, but then also looking at what the legal reality is that Helen just discussed and trying to provide businesses usable, effective, efficient compliance mechanisms to comply with foreign regulatory regimes in this space, data protection and transfer rules, so that business can proceed, so that this system actually will work, so we don't face a cliff edge. And I just want to make, if I could, just a few quick comments as to what I think the three considerations are that guide our thinking in that regard. And to my mind, one is pretty obvious. It's pure and simple economics. Another is perhaps sometimes unappreciated or underappreciated, which is privacy. And then I think the third is trust. And I think we all recognize kind of the economics of this. In the US-EU context, data flows completely underpin our trillion-dollar trade relationship. I think that is well appreciated. What I'm not sure is as well appreciated sometimes is how much they underpin kind of our investment relationship on both sides of the Atlantic. That's much bigger. It's about $4 trillion. And why that's important is because it enables jobs on both sides of the Atlantic. I recently learned that, this should have been obvious, but that EU companies in the US, US companies in Europe are the biggest source of onshore jobs in each other's economies. 4 million jobs on each side of the Atlantic. And that becomes important in this context, to bring it back, is because HR data, as we all know, in EU cannot be transferred under EU law using consent. So that's where these mechanisms become important. Under EU law, we need a mechanism. Privacy Shield, close to my heart, comes into play in that context. In terms of privacy, I just think that this is underappreciated, that these mechanisms create binding and enforceable privacy protections that we've all agreed on. So, what would be the impact of these things going away? Not just the economic side of things, but actual impacts on privacy, because these are enforceable obligations companies sign up to. But then the piece here that I think sometimes is not talked about quite enough is the trust component. We all know that individuals need trust in kind of the digital ecosystem to use it. But the way this has all been set up, these transfer mechanisms are built on the premise that we can create enforceable obligations that can exist across different types of legal structures, different legal systems in our countries. And if nuances in the legal approaches in different countries mean that those frameworks are invalidated or can't stand, then we have a real problem, because if one can't exist based on that premise, how can we trust any of them? I think they're all very much linked. So I just wanted to kind of make those quick comments and say, those considerations are certainly what's driving our administration's full and ongoing support for Privacy Shield and the efforts we put into that. But I think they're important considerations for all of us.
Great. Thanks, Caitlin. That's terrific. In fact, pragmatism, a word, Axel, you probably live every day. I mean, what's it like to be in your shoes? You're a controller, you're a processor, you have over 300,000 employees, subsidiaries all over the world. We were talking outside at the break about this topic, and it just seems like there are some pretty compelling business situations that you run into every day.
Yeah, thank you. I was afraid that you asked me how we prepare for the Brexit.
Oh,
yeah.
Okay, yeah, answer that too.
And I would like to refer to Claire, but she only prepares for the UK companies, saying that the EU is adequate. And maybe we should simply agree here that we do it otherwise. and because there's no solution on the EU side yet, and it seems like it will be we're not agreeing on model clauses with our UK companies, customers, and so forth. So I don't have a solution in place, whereas business is really pushing on me and saying, where is the solution? Do we have one? And I'm sure when January, February comes, they will ask me, so how big is the risk, Axel? Yeah? Can we continue transferring data from Germany to UK to our customers? Can we receive it from the suppliers in a compliant way? And yeah, I don't have a solution for that. And then they will say, yeah, but I told you a year ago. So that brings me back to what Peter said, that they updated more than 12 million contracts in the past. And I mean, most of you are forward thinkers and politicians. I want to show you the scenario how these contracts look like. If we sell, let's say, our IoT solution to a car manufacturer in Europe, that means we're selling it not only to, let's say, Volkswagen, but also to Volkswagen subsidiaries all over Europe. So we have already, let's say, 20 or 30 data controllers. And you all know the contract, if you have an international data flow, it must be between the controller and the processor in the US or India if we offer a 24/7 service. So it's not only the contract between Siemens headquarter and Volkswagen headquarter. No, it's the Volkswagen subsidiaries with Volkswagen headquarter with Siemens headquarter with all the Siemens subsidiaries, and then all these cloud providers, maybe in India, maybe in the US. So that's around, I don't know, a couple hundred contracts. And if you do it in a diligent way, it's it might be easy, but for a smaller company, you really need to be an expert to do this, because you cannot simply shift around the contracts and ask all your subsidiaries for a signature and then hand it over to Google Cloud or AWS or SAP with its another 30 subsidiaries somewhere in the world to sign it as well. So, we are wasting too much time on such contracts, and then we do not have time to think about security, about privacy. Because simply agreeing on model clauses, does the individual really benefit from that? I doubt it, but we have to do it to be in a compliant situation. So I really ask the regulators and the politicians to think about this and to offer pragmatic solutions for that. Also, if we go towards March of next year, if we look to the UK.
Okay. Did you? Wade carefully. No.
Thanks for that, Axel. So I think, I should frame that hopefully what we will achieve is a deal. I think that's in the mutual benefit of interests of both sides. And from the UK's perspective, we not only want a deal that enables the free flow of data between the UK and Europe, so an adequacy agreement, but we also recognise, because the UK will be the largest trading partner for Europe, that we would like to have a regulatory cooperation agreement as well. Because of the interface with business. So if you kind of think about it from our perspective, when we work closely with our regulator, the Information Commissioner, what they are looking for is to make sure that we have harmonised rules, so that businesses in the UK will not have to have a different interpretation of the law from a business in Europe. And to achieve that, you need regulatory cooperation. So it's something that the UK government is pushing very kind of forcefully, and trying to make sure that in the future scenario as we exit the European Union, that we are providing that certainty for businesses on both sides. We think it's in nobody's interest to have divergent regimes. We've got high data protection standards in the UK, we've got a Data Protection Act, we've got a well-funded, resourced Information Commissioner. What we want to make sure is that continuity stays in place. In the unlikely event of a no deal, what we are seeking to do is exactly the same. We're trying to replicate that. That's why we want to start the adequacy process now.
I'm starting to think there's no disagreement between anyone on this panel, but of course there's a disagreement perhaps, or a difference in emphasis in the way we're coming at the same issues. Of course, Axel, you're absolutely correct. There must be solutions. Users require them, businesses require them. We heard about and the Irish High Court heard about the trillions of dollars of global trade that depend on transfers. The issue, I suppose, really is that the solutions need to be clarified, and that's why the litigation is going to be important. And it's why it's important that the litigation was comprehensive in terms of how it dealt with this, so that we're going to get the ultimate guidance from the CJEU on how the standards have to be met, so that the solutions that are implemented, and they will be implemented, transfers can't stop, but the solutions that are implemented are going to be legally sound in the direction of higher standards of protection for users at the same time as facilitating the transfers. So there are already some positives in the GDPR in that until the CJEU invalidates, if it invalidates anything further beyond safe harbour in 2015, there are already some positives in the GDPR in that it expands the numbers of solutions that are available. It put binding corporate rules on a statutory footing, and it expanded the use of binding corporate rules to industry groupings rather than corporate structures, although I have to say we haven't seen any applications from industry sectors so far. But what we have seen is a huge increase in the number of applications for binding corporate rules to my own authority, and also I know the ICO has updated that it has 40 plus applications in hand. And of course the binding corporate rules are a really useful way for global organisations to implement full compliance programmes with the GDPR. So these are the positives, and whatever solutions are there now and as clarified by the court, if there are any gaps in the way they're being implemented, these will apply equally in the case of post-Brexit scenarios if there is no deal or if there isn't ultimately an adequacy finding. The other thing to mention, I'd been mentioning to Caitlyn earlier that some of you may have noticed that the European Data Protection Board plenary was on Tuesday and Wednesday of this week in Brussels. I've come from it yesterday. And the press release from the EDPB yesterday indicates that we approved a paper on the extraterritorial scope of the GDPR. But importantly in that paper, when you see it, when the press office publishes it on Monday, I anticipate, you'll see that there's a very important section in that paper that cross-references the Article 3 extraterritorial reach of the GDPR with Chapter 5 transfers. And there are going to be lots of examples in that paper that will be published, in fact, for consultation, so you'll have a chance to input on it. Lots of important examples that are going to demonstrate where effectively a transfer, while it is a transfer of data, it won't be deemed a transfer under Chapter 5 because the receiving entity will already anyway, by virtue of Article 3, be subject to GDPR. So there are lots of solutions there. If the court clarifies that there's gaps in those solutions, they'll be fixed. You can be assured of that, Axel, that regulators and policymakers are going to plug the gaps once they're clarified to us.
Can I actually continue on that, Helen, because you made a really important point, I think, about differences of emphasis but not necessarily disagreements. And the question I have is actually more of a process question, which may seem kind of mundane, but ultimately I think movements in rules and large conceptual frameworks depend a lot on just people talking to each other. And you have a reputation, I think, well-deserved for being both, having a high fidelity to the applicable legal framework, but also just being open as a person and always willing to talk. What observations do you have, or what things have you learned in your time as DPC that could be helpful both for companies, but also maybe for your fellow DPA officials in the brass tacks of interacting with companies and working through practical problems and in giving, not necessarily filling in the gaps of the law, because of that's of course the overriding framework, but in giving meaning to them and exercising discretion? Are there things that companies can be more active about or do a better job of in solving these problems?
I don't think I'd purport to offer advice to any of my fellow DPAs, but you're absolutely right. Conversations like this are important. I think ultimately convergence in laws is going to be very important on top of the talking. But I think you raise a very good point, and the reason why my authority believes so much in engaging with companies and companies from lots of different sectors, it's that we need to understand what's actually happening on the ground, because if we don't understand how sectors work, if we don't understand how industry works, then we're not able to interpret the laws to give effect to individuals' rights in a way that reflects how reality works. So, I mean, really all I would say is, while we await legal clarity, if there is further clarity to be provided, and as we implement the solutions, as this paper from the EDPB goes out to consultation, and I'm sure there'll be very active consultation on it, we do need to keep listening and we need to keep talking.
Great, thank you.
I sometimes have a fantasy, to Claire's question, about, well, how do you get people to realize what international data flows mean to them? And so I propose, we pick a date, and I don't know, November 4th, and every company just shuts it down that day, 24 hours. We shut it down, and we see what happens. I mean, I know it's a fantasy, but I think it would be pretty shocking for people to realize how embedded all of this international data flow thing that can sound very abstract is to actually how every single thing runs. In other words, nothing would run, right? It would just be, Armageddon of our economies for whatever period of time it is. To Helen's point about convergence, yeah, there is more convergence going on now than ever before. I mean, there were congressional hearings in the US yesterday on privacy, and we saw industry leaders from a bunch of companies in the US supporting the development of US federal privacy legislation, which for many of the European skeptics is something that people have not thought was likely to happen. But as far as I'm concerned, it is likely to happen, partially motivated by preemption of a duplication of state privacy laws, but that's the way the American federal system works, and partly just by an expectation of consumers that this thing of privacy is becoming of grave concern to them, and they think that laws and regulators need to do something about it. So, I mean, there really is a convergence. That being said, we are not going to converge as a planet on the GDPR as a model. So there will be variations from country to country, which is why the whole adequacy framework was always a bit odd, because the adequacy framework essentially said, you don't need to have high privacy standards, you need to have these privacy standards, is essentially what it said, which is why there were so few countries on that list. So what I would propose is, I'll come back to this very basic idea, which is we are jumping through hoops, we are engaging in legal fictions, we are trying to explore all of these different compliance regimes around mechanisms for international data flows. But really what we want, is every data controller to protect the data according to the same standard worldwide, regardless of where it transfers, where it sits, where it's stored, where it's accessed. We keep using even the word transfer. I mean, I don't even know what a transfer is, honestly, right? I mean, transfer is, again, one of those metaphors for human speak, where I'm sending the data somewhere else. Really what we're talking about is if I'm on my little device and I can access my bank account that might be sitting in, I don't know, some other place, have they just transferred it to me, or did I just access something off of a server in a different locale? So I think we need to really step back from all of this, re-examine the reality of the technology, re-examine the reality of just what these flows mean to all of us, and then, start fresh, not be prisoners of a particular optic of way of looking at this for multiple decades. Technology goes stale, we sunset it, it's gone, it's dead, we move on to the next thing. We could do that in legislation too, right? I mean, legislation can be improved, modernized, brought up to speed. And again, I'll just be absolutely clear, I am not talking about lowering privacy standards. On the contrary, I'm talking about the same privacy standards worldwide.
So Axel, on that, I mean, put you on the spot a little bit. As a global company, how would you think about some of the key I'm just going to assume that you don't like fragmentation and that set of rules would be in your interest. But beyond that, how do you think about some of the core principles that you'd like to see out there at whatever level, issued by whatever government that govern your activity?
My wish is that we really differentiate between sensitive data and data which can just flow around. And the latter means, for example, contact data, which, maybe you still know these yellow books in phone cells, with phone numbers and addresses lying around for everyone. This is public data, of course the regulators would say no, it's not. But for me, contact data, just the name of our employees, for example, and the email address at Siemens.com, maybe we find lower hurdles to transfer such data. And also, if we talk about the e-privacy regulation, maybe we can carve out the employer-employee relationships, and because, as you mentioned, the consent is not feasible in the employer-employee relationship, and that would take a lot of burden from the enterprises. So this is could be one milestone. And what Peter said, I agree. Why don't we simply say you can transfer data to another company if it agrees to comply with the Gdpr or with the Canadian law? Then we don't we don't have to agree on model clauses. It would make our life much easier, and then we can concentrate on security issues, for example, which really safeguards our personal data. So maybe we take these two things also into account. And I think the sensitivity of data, we should really look on that issue more closely.
Great. Please.
I'm sure Peter and Axel realize that as regulators, we share some of their fantasies. Not everything written in the GDPR is the way we would have written it. And of course, we can agree that the language around using the word transfer, it doesn't have precise meaning in the real world. But as I said earlier, I think we can create an understanding of what it does mean, which is around potential access to data that attracts rights in one jurisdiction that could become absent in terms of access in another. You raised the issue, Axel, of personal data. I think there are a lot of people that have talked about the blunt instrument that is the definition of personal data under the GDPR and EU data protection law. I had counted up, because my own authority was the subject of a reference case to the CJEU in 2017 in relation to the definition of personal data, concerned a handwritten examination script in a professional accountancy exam, and whether that constituted personal data. It did, according to the CJEU. But there have been over 19 or 20 cases, reference cases to the CJEU in terms of the definition of personal data under the directive. So it's such a broad definition, it's not necessarily understood. It doesn't distinguish between, as you said, names and addresses and so on, and then other more sensitive cases of data. I'm sure many of you saw the ruling of the CJEU on Tuesday of this week in relation to MEPs' expenses. And the CJEU found that that data does constitute personal data and wouldn't fall to be given out under FOI requests. So there are, of course, arguments there, but sorry, just to be briefer, the point I was going to make is you have to be capable of distinguishing between lawmakers and policymakers and regulators, on the other hand, that are enforcing the GDPR. We play our part, like you, in contributing to the debates on evolving these concepts so that ultimately new laws do evolve in a way that reflects reality, but at the same time, it's a road to nowhere for us to try and create what we think the policy approach should have been. All that said, we will try to take a common sense and sensible approach always where we can.
Great. Thanks, Helen. I think we've got a few more minutes, and I understand, maybe contrary to perception, that there is not a bar on audience questions, so I want to reserve our remaining time. I'm not sure if there are microphones around, or if people, if you have a question, maybe just stand up and project your voice. Oh, you do? Okay.
All right.
Wow, that's big. All right. Is it a mic? What is it? Oh, okay.
So thank you. Just to echo back the question for those who couldn't hear, it was, will the UK be deemed adequate? And what has been the UK's kind of implementation of GDPR domestically? So currently we passed our Data Protection Act in May earlier this year, and that gave effect and aligned us with the GDPR. When we leave the European Union, all we will need to do is make a few technical fixes to our domestic legislation to make sure that what's held at the supranational level in GDPR works at the domestic level. So effectively, the UK will be fully aligned with the GDPR when we exit the European Union. On top of that, if you look at the areas that are scrutinised as part of the adequacy process, so one of the key things is an enforcement mechanism, how independent our regulator is. So the ICO is currently one of the most well-funded regulators in Europe, currently very, very active in the EDPB, playing a very, very strong role in providing guidance, circa kind of 50% of the guidance. I think last year the ICO played a role in. And they also value their independence and have a very, very clear remit from the UK government that they can conduct their investigations without interference from the UK government. And that's something that we know will be scrutinised as part of the adequacy process. And we believe that the ICO has a strong story to tell in terms of how its record has been lived out in the UK. The other aspects that will be scrutinised, obviously, is our investigatory powers regime. And again, the UK has previously been accused of having, surveillance rules that interfere with individuals' privacy. I would point you towards the UN Rapporteur's recent appraisal of the UK, who says the UK government has come to great strides to bring the investigatory powers regime up to date in the UK, and has now got one of the most strongest privacy protections in place for its citizens in Europe. So I think in terms of our readiness for the adequacy process, we're ready to do that. We have got all the information ready, and we believe that we should be able to be deemed adequate as we exit the European Union.
Great. Any other questions? Please.
I have a question. Can you hear me? Should it work now?
Hey.
Can you hear me?
Yes.
Okay.
Is it also for Claire?
Yes, this
Okay.
is for Claire. I just wanted to ask, this is cool. I mean, we know that the GDPR will be applied in the UK, but my question is, considering also what happened with the safe harbor, would the adequacy also be the same if the UK is not subject to the ECJ rules? So if there is basically another safe harbor decision at ECJ level, but that does not automatically apply to the UK because the UK will not be subject to the ECJ
jurisdiction
rules.
of the court.
How is that? Yeah.
So I think the question that you're asking is how does the UK continue to remain aligned with the GDPR as it potentially evolves in the future? So this is something we're very alive to. One of the things that we have proposed is that we have a dispute resolution mechanism as part of our adequacy decision, so that we have a process whereby if there are CJU decisions that say that a certain aspect of UK regulation is currently now in breach of GDPR, that we have a process with the Commission where we can work through it and make necessary amendments when they're required. So one of the things that we are very keen to avoid from a UK perspective is a repeat of safe harbour. It's why when we put our proposal, which is out in the public domain, to the Commission, we very much said we wanted to go beyond the standard adequacy decision for exactly kind of the reason that you've pointed to, that actually if you consider the volume of data flows between the UK and Europe, what we do not want to have is a decision that impacts hopefully a future adequacy decision without a process in place for how the UK government would engage with the Commission on that issue. So that's something that the UK government is very supportive of, but obviously it's subject to negotiations with the Commission.
Great. Axel, you want the last comment?
Yeah, let's face again the reality. I don't think there will be an adequacy decision from the EU side, just to put a lot of pressure on the UK government. So, Helen, what do you think, if you were sitting here, what shall companies do? How can we prepare? I think there will be a gap, maybe in April and May, without any adequacy finding. And then my guess is when next year in the summer we'll have an adequacy decision on this on the side of the EU for the UK. Do you agree, or do you have other good recommendations?
Nobody knows the answers to all of these questions, but first of all, it is the case that if there is a deal, if the UK leaves with the deal, there will be free flows of data for the 2-year transition period. So from March 2019 until 2 years from that point, there would be free flows if the UK leaves with the deal. If it leaves without a deal, it's only at that point that there could even be a commencement of the negotiation process for an adequacy procedure. So you're absolutely right, there would be a gap in any case if it is the case that the UK leaves with no deal. In those circumstances, as I outlined earlier, Chapter 5 of the GDPR outlines the range of mechanisms. Yes, they may be subject to refinement or alteration based on the outcome of the CJEU cases in both the La Quadrature du Net and the Irish High Court case. But there are binding corporate rules, standard contractual clauses, and other mechanisms for transfer there. So I would advise that companies start familiarizing themselves with them.
Caitlyn, final thought?
Yeah, I feel the need, since I think our colleague from Bitkom began this discussion by referencing the uncertainty around Privacy Shield, and certainly we've talked now a lot about the litigation, to just make the comment, and I hope this is clear, that on our side in the U.S. government with regard to Privacy Shield, the commitment couldn't be stronger, that we're preparing very closely and have been for some time now with our European Commission and DPA colleagues for the second annual review, and are very much confident in the strength of the Privacy Shield framework and the oversight mechanisms that we have continued to work throughout this year to put in place with the Commission to address all of the recommendations from last year. And I think that message does get lost a little bit. We put out a few documents recently that hopefully try to address that, publicly put out a 34-page response to the European Parliament's resolution, for instance, in excruciating detail, addressing some of the points raised. Of course, the U.S. submission made through Irish counsel before the Irish High Court in the court case is also fully public and on the Department of Justice's website. So I just wanted to kind of convey that the U.S. government stands behind all of these mechanisms and has continued to engage in full support of them.
Great. Thanks, Caitlyn. This conference has been almost perfectly on time. I don't want to be the person to screw that up too much. So let me thank the panel for a terrific discussion and thank all of you for being a part of it.